All right, how you doing? This is Jerry McKee with Prime Time, and welcome at 7 o'clock. You can tell every Monday at 7 o'clock we're here, and got a great treat for you today. If you ever wondered about your wills or anything that legal-wise, and we're going to have a person here that's going to be able to answer your questions. Sammy, we've got here at Diamaduros from the Diamaduros Law Firm, and he's going to come and in just a couple minutes, and he will answer your questions. If you like, you can call it a number. We'll have a number down below also. So welcome to Prime Time, and we're going to go to our sponsors. If you just give me 1 second, do a couple little clicks here, and here we go. That's one thing about being a one-man show. You got to do a lot of clicks yourself, and of course, everybody's used to that. And okay. And now we're going to the commercial.
Jewelry has the power to be this little thing that can make you feel unique. Being a true gentleman never goes out of fashion. People will stare. Make it worth their while. For the woman of your dreams and the jewelry of her dreams, rings, pins, and pendants, fabulous rubies, sparkling sapphires, brilliant diamonds. Keepsake Jewelers. We are the jewelers who understands what dreams are made of. Dreams of gold, dreams of emeralds, and dreams of diamonds in pins, rings, bracelets, and earrings. At Keepsake Jewelers, we have whatever it takes to make her dreams come true. Visit our new location, Keepsake Jewelers, 441 North Duncan Bypass, Suite 5, Union, 864-427-5100, 864-427-5100, Keepsake Jewelers, Union.
All right, we're back. Hope you enjoyed that commercial. Always go down to Keepsake Jewelers and have yourself a big old diamond for your wife or your girlfriend or whatever you want to do for all occasions, just to go visit them. And now I'll turn you over to our guest here, Sammy Diamaduros. How are you doing today?
Fine, thank you. I'm glad to be here.
Yeah, I'm glad for you too. One question I want to ask is what got you started in wanting to be an attorney of law?
Well, when I was young, my dad opened Hart's Restaurant before I was born, and as he worked 7 days a week, 12, 14 hours a day, he told me he didn't want me to go in the restaurant business. I need to do something else. So somehow or another, we leaned towards law school. I loved to talk, loved to argue when I was young. I thought, what better profession than just being a lawyer and doing it my whole life.
So you love to argue.
I love to argue.
That's pretty good.
It's part of what we do. We have to argue. We have to advocate, and that's.
Well, people don't realize that the restaurant is hard work. It's not an easy chore. You probably didn't see your dad much unless you went there.
He worked 16-hour days, 7 days a week at one time.
He put you to work in there some?
I did work weekends when I was in high school.
Now, you went to Wofford?
I did. I went to Wofford undergrad, Union High graduate in 83 and Wofford in 87 and USC Law School in 90. And I laughed because I have a Wofford shirt and you have a Carolina shirt, so I went to both.
Well, that's good. So you went to law school in?
South Carolina.
In South Carolina, okay. And a lot of people have some misperceptions of wills, and when should they make one? Because a lot of younger folks seems like that's just when you get old, like myself.
I think most people think that. There's not an age to do it. I know that your average 20, 30-year-olds won't. I think the first people think about it is when they have their own children, and then or when they get older. But it's we do basic wills and basic power of attorneys and deeds. We're not estate planners, but still, most people should have a will at some point in time.
Right, and when people don't have a will, does it make it more complicated, especially if you got a lot of children? The estate, say if you have land, does it make it a little bit more difficult?
It makes it more difficult, but it doesn't absolutely. So a lot of people believe they don't have a will, their property will go to the state or something. That doesn't happen. So if you die tomorrow, your property will go half to your spouse and half to your children by intestate laws.
Right.
Doesn't matter if you have one child or 10 children, it's half to the children, half to your spouse. If you didn't have children, it's all to your spouse. If you don't have a spouse, it's all to your children. So it goes intestate laws, but you're better off with a will because you can tell who gets what and who has power over the probate matter. Either way, it has to probate. So some people believe if you have a will, you don't have to go to probate court. You still have to probate the estate.
Okay. Well, that one thing you did mention there, a misperception people have, and I've heard it many, many times. Well, if we don't have a will, then the state's going to get everything, and everything's going to be tied up, and nobody's going to get nothing, and eventually the state gets it.
That's incorrect. So it goes to your heirs, but you don't control how it goes to your heirs. So one of the best things about a will is when you have a will, you appoint a personal representative. And in most wills, that person handles your estate, but that person has the ability to sell assets or do things to move the estate. So if you pass, the personal representative can sell property to pay bills or whatever's necessary. If you die without a will, they cannot, without a court order or after the estate's closed. So it inhibits and prevents them from doing things you could do with a will.
Okay, so what is your suggestion for someone to make a will out? Is it because that right there is a lot of confusion goes on that, well, I got to wait till I get old, or I got to wait till I get married, or I got to wait. Is it more if you have a lot of assets, or?
Well, I think it's obviously if you have lots of assets, it's more important. You have estate planning. Now, again, nobody in Union, we're not really estate planners. We do basic wills and things of that nature. So if you're very rich with lots of assets, I believe it's over 10, 11 million now, you should probably go to an estate planner because that's when inheritance tax kick in. When I started, it was 600,000 would make inheritance tax. Now it's over 10 million. So we don't have many people that need the estate planning as much around here as they used to. But everybody needs it, even with children. Like I said, just a small estate, if you pass and you have a mortgage and there's not a person representative, they don't have the ability to sell things, to pay bills or pay taxes. And some people have a lot of bills.
Right.
So, again, it won't go the wrong way, but it'll go the way you want it, because not everybody wants their property split half to their spouse and half to their children.
Right.
They might want it all to their wife first, or their husband, then to their children. So everybody don't want to follow the intestate succession.
Now, if someone did not have any children or anyone that they could leave it to, what happens to it then?
Well, if you have no heirs whatsoever, which is rare, because usually you go down, you go wife and spouse, then you go parents, then you go brothers, then you go niece and nephews, cousins. It'll hit anybody that's left. If you have no close family or relatives, then I would encourage people, you'd still want to do a will because you want to direct it to a neighbor that took care of you, a charitable organization, a church, something you could at least name on your own instead of it just going to the state, which rarely do you see because usually there's an heir. But if there was no heirs, it would actually go just to the state.
Right, because I know, of course, we know Hollywood and television that we've seen where somebody says, well, they find a fifth cousin way on down the line, hey, you inherit this.
It's possible.
Yeah.
If you don't have a will. And another thing people don't understand, some estate planners have told me the problem with doing a 1-hour podcast like this is you could have all-day seminars on wills and estates and deeds and all that, and people still wouldn't understand that it's very complex and deep. It's hard to synopsize it, but we do our best we can.
That's right. And if someone wants to ask a question, you can call 864-441-9200. 9382. Excuse me, 9382. If you have a question to ask Sammy. Now, you made a good point there that it's very complicated. And I see online where, fill out your will online. That, to me, I know I went online and looked at one that's before, of course, we had you do ours. And I just wasn't really comfortable with the legality of it because it's kind of uses sometimes just generic.
So I don't like the online wills. There's nothing wrong with them. If you do a will and you type it yourself and you have it signed and witnessed by two witnesses and properly notarized, it can be valid. But I tell people this isn't something you do every week or every month. Some people do one a lifetime. A basic will in union is about $200. It just seems worth to pay somebody to do it and make sure it's done right instead of taking a chance that you might do something wrong.
Right. Now, those wills, do they get registered into registered deeds or?
So wills, so when you get to a will, you take it home with you and you put it in a safe box or your safe deposit box. Most people don't know that. It's a good question. It doesn't go to the courthouse. It doesn't get filed in probate or anywhere. But once you pass, your family will then take it to probate court and it will be filed in probate court.
Okay. Well, and that's another good reason to actually have an attorney to fill out your will, because what would happen, say if you fill it out online and or got it and typed yourself and you put it in the box and it gets missing or gone.
If you lose it or you have a copy, it's no good. So a copy is as good as not having one. They won't accept it.
Well, I didn't even know that.
It has to be the original. So when I give people a will, I tell them keep it in a firebox, safe deposit box, or somewhere. And you can keep a copy, but a copy is no good at all.
Oh, okay. So they so they really couldn't come back to you and say, okay, I need a copy.
We keep a copy in a file, but they're no good. And the reason being is if you did a will and you gave your son a copy, you could never get rid of your will because he'd always have the copy and could always use it. So they don't want to use any copies. They assume if you wanted the will, you'll have the original taken to probate court.
Well, that makes sense because someone can actually come in and try to change the will.
And I'll tell you something else that people get confused on is when you have a will, they don't know where to take it. Everybody still thinks it goes to the courthouse. It does not. And then people don't understand what a power of attorney is. I don't want to mix them yet, but a power of attorneys are what you use while you're alive. The will kicks in the day you die. A lot of people think they overlap. They don't.
Okay. Yeah, because I thought the same thing. I thought, well, that when you die, that the power of attorney comes in, that the person was over all of this, your estate.
And lots of people think that. They think that I have a power of attorney. My dad died. Can I go get the money to pay the bill? But a power of attorney ends at death. Okay. And the will kicks in at death.
Now, a lot of people are scared about giving someone a power of attorney because they think automatically that, well, I'm going to give this person a power of attorney. I do trust them, but, they might get mad at me and just wipe me out.
That's actually a very valid question, and they can. So if I got a power of attorney for my parents and my brother, we both do, it gives us the power to buy, to sell, to handle their assets, finances. So I could, in theory, if that person's crooked, he could take money because he's got a legal power of attorney that says he can take money out of your account. Now, there's repercussions. There is a fiduciary duty of the power of attorney not to misuse it. Mm-hmm. And it could be criminal implications, but both of those I've seen rarely.
Right. And do the person that's a power of attorney, if they spend anything out of that person's money, like do they have to have accountability for receipt or anything?
They don't have to have any type of accounting because it's just a power of attorney. And believe it or not, there's no, they can give, so some power of attorneys have the ability to make gifts. So you can give your son a power of attorney and he can make gifts to himself. Some prevent it. So people say, why would you want somebody to make a gift? Because if you got old, you may want your son to be able to get money if he needs it, just like you would give it to him if he was here.
Right.
And others is like, I don't want somebody to be able to make a gift to themselves. So that's actually a paragraph we put in or take out of the power of attorney.
Okay. And the person, say it's a power of attorney and the family comes in, maybe say a sister or of the person that you're power of attorney over, and they try to say, we want to do this, we want to do that, we've got to do this right here. And they think that since they're either their cousin or their brother or their sister or another even family member without that power of attorney, that they have power over that person because they're kin.
Power of attorney stands alone, and we do a lot of power of attorneys that are and or an or. So you could put if you had two sons, you could put John and Joey, or John or Joey. So if it's or, they could act individually, or together. And if you put and, you could put the act together. That creates complications because they always have to both be together. But if you're worried, that gives you a little protection because it takes both of them.
Okay. Now, say, for instance, my wife and I, we have a checking account, savings account like that we got together. Is there a better way to say if one of us happen to pass away that the other one, they won't close the account? Is it?
I would go to the bank, and what I would suggest is most accounts that are husband and wife, no, well, I'm not say that. Some husband and wives like separate accounts, but if you have a joint account,
Right.
I would just do an or account. So it would be me or my wife, and then if one of us passes, automatically the other ones, they can have complete access. And that's what most banks recommend, because then either of you can sign a check or take or withdraw money.
Right, because I've seen that happen before where, and actually, a friend of mine that I took to the bank, and her husband just happened to pass away within hours after that, but she went to the bank and they changed it for her with his signature and notary and witnesses, and they just that nick of time because they told him so this will be frozen if.
Yeah, so some people have payable on demand, POD account, so it's your name, but when you die, it's payable on demand to your child, for example. And that works because that means you control it while you're alive, and it goes to them when you die from the bank. But if you trust, like your spouse or a child, you can put their names on your accounts. Like I said, bank user would tell you to do or. So my parents have both their names and mine and my brother's name, so all four of us are on the account with all ors. I mean, either one of us could take money or any one of us could get to that account. That's the safest way, but that if you don't trust somebody 100%, if you put your son's name on your account tomorrow, that means he can take the money tomorrow.
Yeah, that makes
So-
sense. And again, the one with the power of attorney can have control of that. Now, if you're power of attorney, if that person just got the checking account in their name, is the power of attorney still override to where they can use that money?
Yeah, so if you give your wife your power of attorney and it has the right powers in it, so you got to look at each power of attorney individually, but it has the powers to write checks,
Right.
finances, then your wife can go get to it whether you're healthy, whether you're incapacitated or capacitated. A lot of people think they can only use it when you become incapacitated. No, she can go to the bank tomorrow when you go to Spartanburg and she can take all the money she wants as the power of attorney.
Oh, okay. All right.
If it's got those powers in it. And again, some power of attorneys are very limited. So you could have a limited power of attorney that just says, my wife can sell our house because I'm going to be in Europe, and it's just got one power. So you have to read the power of attorney to make sure it has all the powers.
So you can customize it.
I've had them customized for buy-sales of houses where one spouse might be out of country and they just give the other spouse just for closing a loan, just for deeding the house and doing the loan transaction.
Oh, okay. Well, we're going to take a little break right here. We'll be right back. I have some more questions, and you hear some. I hope you're getting some good information because I know I am, because the questions I'm asking is just things I've heard just out on the street, and just picked it up and went with that, thinking, well, this is true. It's like the internet. Everything's true. It's not. All right, we're going to go with Keepsake Jewelers again, and we'll be right back after this message.
Jewelry has the power to be this little thing that can make you feel unique. Being a true gentleman never goes out of fashion. People will stare. Make it worth their while. For the woman of your dreams and the jewelry of her dreams, rings, pins, and pendants, fabulous rubies, sparkling sapphires, brilliant diamonds. Keepsake Jewelers. We are the jewelers who understands what dreams are made of. Dreams of gold, dreams of emeralds, and dreams of diamonds in pins, rings, bracelets, and earrings. At Keepsake Jewelers, we have whatever it takes to make her dreams come true. Visit our new location, Keepsake Jewelers, 441 North Duncan Bypass, Suite 5, Union, 864-427-5100, 864-427-5100, Keepsake Jewelers, Union.
All right. Whoops, wrong button. There we go. Okay, you're back, and I'm Jerry McKee with Prime Time. And don't forget the number that you're going to call in, 864-441-9382. and we're talking to Sammy Diamaduros and the law firm of Diamaduros Law Firm here in Union County. And we're talking about wills, we're talking about power of attorney, and we might switch the gear here and let's talk a little bit about our health and the wills that we have to make up for, I guess, for living. Now, we talked about the power of attorney and the financial part.
Before we go to the health care, I will
Okay.
add one more thing. A lot of things people need to consider when they come to talk about a will is you can create a will to give your property to your spouse or your children or whoever, but some people do a deed. And so you could take your property, for example, you and your wife, and deed it to your children and maintain a life estate, which means you live in the house, you control the house, you get the reduced taxes if you're on the homestead.
Right.
The house stays in your name for you to live in. But the moment you die, it automatically goes to your kids. Does not go through probate, and it goes straight to them by the right of survival, because your life estate expired when you pass. That would avoid probate in a will. Some people do like that. It's got some advantages and disadvantages. You no longer own your house completely. So if you wanted to sell it or mortgage it, you'd have to get the people you gave it to sign it. You cannot change it. So once you do it, you can't change your mind if somebody's not nice to you.
Okay, well, that would be some people would like to change their will every other
Right, and
a
some
month.
people do, so that wouldn't. And another one is for husband and wife, I usually recommend doing your deed right of survivorship. So when the first one dies, it goes to the other and there's no probate. So your deed should be, in my opinion, should be husband, wife, right of survivorship for most people. That means when you die, it goes to your wife, not to probate.
Okay. I don't remember if we did that or not on ours. That's something we got to think about.
Some people have heirs and assigns, and that's usually what you might get with brothers or friends, because when you pass, you want your part of your real estate to go to your kids.
Right.
But if it's husband and wife, a lot of times it's the house y'all live in, you'd prefer your wife
Right.
get it when you pass and not go to probate and start having to probate a house. So
Right.
there are some things before or alternative to a will. I'd recommend most people, if they want to do a deed, you still probably need a will, but there are things. And I don't want to be like a car salesman, do it, pay for a deed, pay for a will, pay for a power of attorney, because there's a lot of things you can do.
Right. Well, that's interesting right there, because I've seen people when they pass away, like it goes into probate, but sometimes it can drag out sometimes, especially, I guess, to get someone to contest the will.
Usually it's 10 months minimum, but if there's a contesting of the will, it would probably take, well, it could be 8, it could still be the same time frame, but usually it takes a lot longer. I've got some cases that lasted several years before you can get a hearing to contest what's been fought over in the will.
Wow. And what are some of the things that, because you think that the will is ironclad, that, that even if contested, there's no way they can.
It's very hard to overcome a will, because if a will is done properly with 2 witnesses and a notary, usually at one of the attorney's office in town, then the witnesses were unbiased. So you don't want family members or devisees or heirs to be witnesses.
Right.
So it's very hard to challenge a will. The only way, and I've never seen one really done successfully, but it would probably be on somebody being incompetent when they sign the will. And that's really hard to prove, because somebody signs a will 3 years ago. How do you prove if they were competent or not unless there's some medical trail or records? Those are rare.
Okay. I just was kind of curious about that, because you hear people talk, and this way we're getting the straight of it from.
Yeah, well, another thing people don't realize is a lot of people get married and they just do a will and they give everything to their brother or sister or their kids, and they cut out their spouse. Well, in South Carolina, even if you cut out your spouse, she has a 1/3 elective share, so she can sue the estate for 1/3, and your spouse is entitled to 1/3 even if you cut her out of the estate.
Oh, okay.
Or him.
Right. So that's kind of like automatic, since you're.
She'd have to. So if I died and cut my wife out of my estate, she could sue my estate for 1/3. It's an elective share, so she has to petition for it. It doesn't automatically go to her. She has to file an action in probate court to get 1/3, and it should be granted if she's a spouse
Okay.
or he.
A question: if say you're married and you separated and been separated for years, hadn't even got a divorce or anything like that, does she still get the third?
She would actually, in that case, if you had a will, she would still get the third because she's still a wife. If you cut her out of the will, she'd get a third. If you died intestate and she's still your wife and you've been separated 30 years, she's going to get half if you have children. All of it if you don't, because she's your intestate heir. So if you have a will, she could sue for a third. If you don't have a will, then she's going to get half or all, according to if you have children.
Wow.
So if you have somebody that's not involved for a long period, and you don't want them getting your estate, you eventually got to get a divorce before you die.
Well, that's interesting because we've got a lot of people that, and I was surprised about this. Some people I know that was separated but never got an actual divorce.
A lot don't believe in divorce. A lot just don't do it, and some wait, and it happens. People are still married, and 30 years later they die, and a spouse comes in and claims a third or gets more or all of it.
So if they got that divorce decree, that kind of eliminates.
That eliminates their interest, and even if you had a will you forgot to delete, it could void out that interest because the divorce shows that you didn't want the spouse to get it.
Right. Another thing, I don't know if it's a misperceptions people have, where they talk about, well, you've got to leave each child something, even if it's $1.
That's I still hear that today. There's no such law that says you have to leave a child $1 each. If you choose to leave one child all of it and someone else nothing, that's your right. It's your estate, so your spouse has certain rights, but your children aren't entitled to your inheritance if you don't want them to have it. So I don't ever put $1.
Okay.
Most lawyers don't.
Because I've heard that before where someone says, well, I'm going to not give my kids, but this one right here is treating me this way. I'm just going to give them $1. And
the thought process might be that somewhere or another there might be an inadvertent missed child that you wanted to have in your will and you didn't. So I guess if you had an unknown child that you thought might be yours and you gave them $1, it would eliminate that mistake idea. But I don't know anybody that puts the $1 in anymore that I've seen.
Okay. Well, I was kind of curious on that one. Now, about a living will.
A living will would be more, it's a living will, but we'd call it more the healthcare power of attorney.
Okay.
It's more of a state form now. Some hospitals give it to you, and it's free. We do a lot for people, but that's one that gives you all the health, so that the new state form has all the healthcare powers. So it used to be a living will. You just did the right to die and not be on feeding tubes or breathing tubes.
Right.
But now there's a healthcare power of attorney that's state-driven in the statute, and it has healthcare powers. It talks about the HIPAA powers, releases, and you can make consent to surgeries or what hospital they go, etc. But it also has what would be called the old living will powers. And it would say, well, one, it asks if you want to be an organ donor. So that's the first box you mark. And then the next two are, do you want to be on feeding tubes or breathing tubes? And my entire career, 99% of the people put no. They don't want to be on a breathing tube or a feeding tube. And it requires that the doctors determine that you're either permanently unconscious, which would be like a vegetable,
right,
or going to die in a reasonable short time, either way. So it takes a high burden. They don't just unhook you and kill you if you're okay.
Right. So someone's got that power. It's not going to say, okay, pull the plug.
Well, most of the living wills I do, what you call living wills, which technically is the healthcare power of attorney, they don't have anybody designated. So the first block is, I want my agent to make the decision. So you'll give someone else a decision to whether to unplug you or not. The second one is, I want to withhold and deny all of it. I don't want any of it. I don't want to be on a feeding tube and a breathing tube if I'm a vegetable. I'm going to die soon anyway.
Right.
The third one is, I want maximum treatment. In my 30 years, 32 now, nobody has ever asked to receive initial the maximum treatment. And I would say 98% say I don't want it. Maybe 1 out of 50 or 100 say, I want my agent to decide. But you burden somebody. So if you were in the hospital tomorrow, then your wife would have to say, unplug it, and that stresses them a lot. So
right,
it's easier to probably just say, I don't want it.
Okay. So the individual can make something of the
healthcare power of attorney.
Policy.
They would sign. If they don't want it, they don't have to do this. But most people sign, I do not want it if I'm permanently unconscious or going to die in a reasonably short time.
Right. And I know the hospital has no code that you put on there that.
So a DNR is a little different. The DNRs do not resuscitate. So a lot of people in nursing homes have DNRs. That means your loved ones past their prime and they're not moving or eating or doing much, and so if something happens and they choke, they won't resuscitate them. A little different than the living will, because the living will's the healthcare power of attorney is saying, I don't want a breathing tube or a feeding tube.
Right.
But not the DNR. The DNR is just somebody, usually when they're in deathbed, you're just saying if they choke, let them die, just don't resuscitate them. Don't give them CPR or whatever.
Okay. I know it's hard for families to make a decision, and I have seen it. My brother-in-law works in healthcare, and he's seen it also where they just don't want to make a decision of taking them off life support,
right,
and it's very difficult for them. And every time they want to holding to loved one as long as they want, as long as they can, and let's not let them go. And it causes sometimes a lot of hard feelings and hardness in the family.
It's very stressful, so that's why I tell people you want the living will / healthcare power of attorney. I use different names because that's how the public knows it.
Right.
Because you want to mark that if you don't want it, and like I said, almost everybody says, I don't want to be on a feeding tube or breathing tube, just sitting there. Well, go ahead and do it, because that way you don't put the pressure on your spouse or your child to come in and say, well, unplug them. And then somebody says, well, little Johnny just unplugged Dad so he could get his inheritance. But that's not true. Dad didn't want to be on machines. So I tell people, make the decision while you're alive, then they can carry it to the hospital, and the hospital will know we can unplug him.
Right. That's Ed and I was doing the same thing, because we just don't want to put that burden on our children
huge
or
burden.
family members, because we know that we don't want to live in a vegetation state where that you can go for months and months, and that's not living.
Well, if you remember, and most people don't, but it was called the Terry Chavo case, which was during the Bush administration, and it went through the Florida Supreme Court, all the way to the United States Supreme Court, all the way through the U.S. House and Senate. Bills were passed, and it was all over the one lady that didn't have a living will or a healthcare power of attorney that said her rights. The husband said she wanted to die and unhook her from the breathing and feeding tubes, and her parents said she did not. So it went through state Supreme Courts, U.S. Supreme Courts, and U.S. Congress before finally she was allowed to be pulled off the machine and pass away.
Wow.
That created a really big uptick in everybody wanting a healthcare power of attorney / living will, so they could not have to go through that.
Right. And I can see where, as far as the spouses go, and family members and battling together, saying, well, his wife didn't like him anyway, so.
You get that. You get the wife. You get this. You get if it's a second marriage, you get the step kid saying, a step parent didn't even. My stepdad didn't want. He wants to get everything. He didn't want my mother around. And again, people even talk about kids and say, well, they just let their dad die so they could inherit all his money. But so I think that's one of the vital things you need to get out of the way. And if you go to the hospital, they'll tell you they want you to have one, and they'll usually, a lot of them will provide it to you for free before surgery, just so you'll have it. And they'll have the records. It saves them a world of headache too.
Yeah, they ask you now when you go to the hospital what procedures do you have. They ask, do you have a living will?
Well, the reason is because if you go to the hospital and one of your children says to unplug you and the other one says don't, the hospital's stuck. So they want the healthcare power of attorney so they can look at it and say this is what he wished, and we're going to follow it.
Right. That's it. Well, you're listening to Sammy Diamaduros and on some health care and some wills and all kind of stuff here. And we'll be right back right after we listen to a little bit of Keepsake Jewelers.
Jewelry has the power to be this little thing that can make you feel unique. Being a true gentleman never goes out of fashion. People will stare. Make it worth their while. For the woman of your dreams and the jewelry of her dreams, rings, pins, and pendants, fabulous rubies, sparkling sapphires, brilliant diamonds. Keepsake Jewelers. We are the jewelers who understands what dreams are made of. Dreams of gold, dreams of emeralds, and dreams of diamonds in pins, rings, bracelets, and earrings. At Keepsake Jewelers, we have whatever it takes to make her dreams come true. Visit our new location, Keepsake Jewelers, 441 North Duncan Bypass, Suite 5, Union, 864-427-5100, 864-427-5100, Keepsake Jewelers, Union.
All right, we're back, and you're listening to Sammy Diamaduros, attorney at law, and giving you some good information on what to do and leaving a will and other things. And you can call at 864-441-9382 if you have any questions. And I think it's a very informative because, you hear a lot of different things. It's almost like jailhouse lawyers in a way, that they don't know the law, but yet they heard someone say it.
It's true.
You ever get that?
There's a lot of jailhouse lawyers.
Yeah, that they come up and say, well, or they read it on the internet, which we know everything on the internet is not true.
No, it's not Google. I like Google, but it's not all true. But it's a good source, but it's not all true.
A good source to bring you in the right directions. Tell everyone where your business, the Diamaduros Law Firm, is.
We're here in Union at 108 West South Street. We have been practicing in Union. My brother Pete Diamaduros came in 1986, and I came to Union in 1992. For 2 years, I prosecuted in Lancaster, Chester, and Fairfield before I came to Union in the solicitor's office to get experience. And we've been in Union now, him approximately 37 years and me 30, going on 32.
Wow.
We love it being here. And I will say, I love what we're talking about, and I do a lot of this. But if I go to the schools or different places to talk, they have a lot more questions about crimes, drugs, sexual offenses. It's a much more interesting topic because that's where teenagers roll.
Right.
And this is informative, but not as exciting as the criminal field.
Exactly. And so we're going to switch a little bit onto that because this gets us old folks, that's that needs that information that you just gave us like that. Now, Union County is like other counties. The fentanyl, the drugs coming in. I know there's some laws that they're trying to get passed to make it a little stricter. Some of the cases that I know you can't talk about the ones you got, of course. People got the misperception also is that, well, I can sell a little bit of drugs and be a little misdemeanor and get right back out and go at it again. Is there a certain limit that they have, or that the punishment seems like it goes to a different stage?
So there is, and I don't have all the levels on my top of my head, but like marijuana, if you have marijuana, it's a simple possession of marijuana. It's a magistrate court offense. If you have over an ounce, it could be considered possession with intent to distribute, which changes it up to 5 years and makes it much more serious. And you look by, there's a different weight category for every drug, and then they look at how you have it packaged. So if you had 6 bags of marijuana or 1, did you have a lot of money on you? Did you have scales? And they'll make a decision whether to charge you with possession. Or they can up it to possession with intent to distribute, which means you had enough matching the weight or other areas to make it a distribution charge, which carries the exact same sentence as distribution of a drug. So possession with intent to distribute, you met some thresholds, it's the same sentence as distribution, even though judges look at them sometimes a little more harsh towards the true dealer, I guess you could say.
Right, and I guess it also probably got some, depends on if this is the first time they've ever...
Well, first offense, then so first offense might be 0 to 15, second could be 5 to 30, third could be 10 to 35. I mean, so it goes up. So first offense, second offense, and it's usually third and subsequent. And that's usually where it stops, but yeah, they get higher sentences on every one.
Well, I know marijuana, everybody says, well, that's no harm and no like that, but it's still illegal.
It's an illegal drug, and I don't want to debate which one's more harmful, but obviously fentanyl and meth things seem to be much more deadly, obviously.
Right.
But they're all still illegal in South Carolina, and I tell a lot of clients that because they'll tell me, well, marijuana's not that bad. Well, it's still illegal in South Carolina. I think the courts have, obviously, you get less time for the marijuana. The first time marijuana is a magistrate court level offense, several $100s, where first time cocaine or other ones are general sessions and you can get prison. So it's got different sentences, so they know that the severity is a little different.
Right. I had a little segment on the fentanyl and the drugs, and it's so accessible to buy the machine that's off of Amazon even to make the pill, fentanyl. And I know some of the ingredients that comes out of Mexico is like 50 or 60% pure, versus out of China it's like 90%. And does it depend on, or they just look at it just as fentanyl, or do they look at the potency of it?
I think they look, now, I'm not an expert on that fentanyl, but I would say it's they look at the fentanyl, the pill, not whether it's 50 or 60 or 90. So the odd thing about drugs is when I started prosecuting in 90 to 92, and then it came to Union, all the drugs at that time almost were marijuana, cocaine, or crack. Then fast forward a decade or so, and it seemed to shift towards opioids epidemic. There was a lot of Oxycontin, Lortabs, and you all read about that. And then you shift another 10 or so years, and now it went all to meth. And it's like now it seems to be mostly meth or fentanyl, and I don't see as many of the other drugs convictions or charges like these. So we're shifting every 10, 15 years to like a new drug.
Something new that's coming up and
Correct.
taking people out. Because I notice Actually, the coroner out of Greenville was saying that when he first started, and he's been a coroner there for many, many years, that overdoses were like maybe 25 a month or something like that, and now it's like 300 and some overdoses.
The police carry Narcan, and again, the sheriff and the chief of police know more about this than me, but years ago I never heard of Narcan. Now if you get a prescription of Lortab for your own surgery, they give you Narcan with it for overdoses. So, and I come in, I'm a defense lawyer. I did prosecute 2 years, but we're defense lawyers by nature here.
Right.
We do criminal defense, we do civil, we do real estate, we do wills and trust and power of attorneys. We do all the basics, workers' comp, whatever we get to. But I commend the sheriff's office with Sheriff Bailey and the chief with Robbie McKee because they do a good job. And a lot of people criticize them, but they do their job. And then some people will criticize judges. But honestly, the police do their job, and they do a good job, and the judges do a good job, and the solicitor's office with Kevin Brackett's office, they do a good job. But it's not all just throw everybody in jail because the jails can't hold everybody.
Right.
So there is a lot of probations, there's a lot of treatments, there's a lot of prison, there's a lot of get out early, and it confuses people, but that's the only way the system works because there's so many cases.
Right. I think, and you're not rehabilitating someone, just locking them up and not doing any type of rehabilitation.
So it's a fine balance, and I don't know how to fix it, but
Yeah.
between rehabilitation and punishment, I'm not sure rehabilitation works by itself, and I'm not sure punishment works by itself. And I would say some people have really say that the way to it is to try to get to the youth and teach them not to do it, because if you decrease the supply, the demand, then the supply will slowly go away because they only bring it because people are buying it. So if the young generation doesn't want it, then it'll go away by nature.
Right.
But
And a lot of younger generations thinks that this is easy money and they won't get caught. Eventually, we know that they will.
I see that a lot, and honestly, I've never seen anything like the meth, which if you see people on it, they age and their health goes fast, or the fentanyl where people are dying. I don't remember that when I was young, and people did die on drugs, but 30 years ago, you saw a lot of drugs, but you didn't see people just dying and overdosing by the day.
Right, and the transformation on meth within a short time is really, really scary.
It is.
I'm in Greenville a lot, especially at night and things, and because of my work, and I see a lot on the street. And matter of fact, right beside the governor's mansion, there's a park, and I was down that the other day, in the daytime, and I just kind of walked, kind of looking around, looking at the park down there, and there's this guy who's got these vines all around him, and just.
It's a sad world, but a lot of people think unions got a lot of it. But I talked to somebody recently that's in Richland or in one of the bigger counties, and I think they said they have 12,000 pending general sessions cases. That's big court cases. It's everywhere. It's not.
Do you think that I know the overload with court cases and getting people to trial, getting them, because I hear this all the time about the jails, even here in Union, is you got guys in there for a smaller crime, but yet the time they get to trial and things, it takes a long time. What is one of the things that we can do to maybe process that quicker? I know we had the Zoom calls during the COVID, and the judges on the bench and bring them in that way. Is that something that?
I don't know if that really speeds up a lot because you make the defendants come to court, so whether they're live or on a Zoom call, to me that's probably similar timing. I just think that people don't understand when you have a large volume that to go to trial, so if you go to court this week and we plead guilty, and the solicitor office said we're going to move as many as we can, they might move a couple hundred cases. They're going to drop some, they're going to plead some, they're going to give deals. That's how a lot of cases move. But if you say we're going to go to trial, we're going to be tough, and we're going to go to trial and give everybody maximum sentences, and everybody just locks down and goes to trial, they'll be lucky to move a couple of cases a week, 3, 4, 5 maybe, and you'll be more backlogged. So it is a fine line between moving them, punishment, but keeping the system rolling. I don't know a perfect way to fix it.
Yeah, and I don't think anyone else does either. But you hear a lot of complaints out in the community saying, "Well, what's the use? They're going to arrest them and turn them right back out." They just know the fact that they got arrested, and they got arrested for that. They don't know the background. They don't know what severity of it.
We have some very qualified judges, and I think they do an extremely good job of handling sentences. Remember, these judges handle thousands of cases, and then somebody can go pick one and say, look how lenient he was on this one, or how harsh he was on this one.
Right.
But they have to look at a case. They have to make a decision in a very short time, and they see so many cases. For example, drugs. You can't. They're looking at. It's hard to put everybody in jail every day, all day, because there's not the prison system for it.
Right.
So they know they have to try to pick the worst to put them in jail, the repeat offenders or the violent ones, and then try to put these where they think they can get help. They're making judgment calls on the fly to where this person will do good in rehab, or order them drug treatment or drug testing, probations.
And now, the ones that manufacture drugs, and I guess the bigger fish, that's the supplier of the drugs to some of, it's like a trickle thing, he'd give his people drugs to go out and sell them. Is it harder on them when they actually get caught? And
It should be. So what, theoretically, when I prosecute and what the police try to do is they want to catch lower level and have them go up and maybe turn or keep going until they get higher level drug offenders, till you get somebody that's very high and then give them a lot more time. So everybody's trying to, well, not everybody's trying, but the police try to get a lot of the lower level to work to tell them the higher level. And they charge you more serious, but to the press and when you read the newspaper, it just says John Doe distribution, the next John Doe distribution. Most people don't really know the difference between how many grams. They don't follow that. They just say distribution. So
right. They leave out a lot of the information.
You can have so I've had people that have been charged with distribution where they bought pot or marijuana and then they split it and sell it to their buddies, and they're in college or something. And they're charged with dealing just like a kingpin almost, but it's really not as much of a dealer. So judges see through that. So a lot of times people don't see what judges hear in court. Then you've got to see, again, they see family attachment, they see work histories, they see prior records. So judges aren't rubber stamps, and judges invariably are going to make law enforcement or defense lawyers mad at different times because they're always making decisions. And a lot of people give them grief, but they do the best.
Well, yeah, because like you said, the courtroom stays full. It's never, well, I don't have any cases this week.
No, we've noticed, and I will say this, though, when we started, we seemed to get a lot more drug cases that we were hired on. Now, we don't have as many. The public defender gets people that are indigent and can't afford a lawyer. So the public defender's office has the vast majority of cases forever in General Sessions Court since the time I've started. But I think most of the lawyers in Union and Spartanburg would probably tell you there's a downtick in a lot of the drug cases being privately hired. And I think that's just because back then you just had more drug. It seems like it had a different culture. But now the people that are own the meth and the fentanyl, it seems like they're worse off, and none of them hire private lawyers. Most of them aren't doing well, and they just don't have the funds or the jobs.
Well, one of the judges actually let me bring my camera into the courtroom on the
good.
case. And I had to fill out, of course, the form, just like the media form, and certain guidelines. And I enjoyed that quite a bit. He asked me at the end, so what do you think? You think it went the way it's supposed to? And I said, well, not really. He said, really? I said, yeah, I thought this over here. And he kind of laughed a little bit. But I think that if we put cameras in, and of course you have to protect some that's innocent, of course, and on some of those, especially the bigger ones like that, expose and let the people see what goes on in your courtroom, and I think they would understand more.
Well, I think there's a pro and con to cameras, just like there is to not, because
Right.
you turn it into a showboat for the lawyers and for the defendants and for everybody. Instead of justice, people are trying to showboat so they look good on the camera. So I think I've heard both sides. I don't
Right.
really, doesn't matter to me which way they go, but I think a lot of people criticize the system or some part of it, but I don't think there's a better system in the world than the way we do it.
Right.
Not perfect, but I don't know where a better one is.
No, but if you go over other countries and you can see how they do theirs, and yeah, we have a.
Some countries don't have a lot of rights, and they might put people in jail more, but I'm not sure that you're just looking to put more people in jail. There is constitutional rights, and some countries don't adhere to that as much. So
Right. Now, to me, when we talk about drugs, to me, alcohol is a drug. It's just a different type of alcoholic that would come, and DUIs.
correct.
We have quite a few of those that pop in.
Yeah, and through my career, we've obviously done criminal defense, we've done DUI defense, and those two are gauged. So obviously a DUI is a magistrate's court level offense that usually results in a fine if someone loses. But obviously if you hurt someone, I tell a lot of my clients, number one, you can kill yourself or paralyze yourself. Number two, you can kill somebody else. At that point, it's no longer a simple little DUI that you're going to get a ticket and you're going to go home and you're going to be okay. You're just going to have to pay some fines and do some ADSAP, alcohol, drug abuse counseling. But now you're looking at extended prison time, rightfully so, because you've hurt another person, an independent person, an innocent person that was just riding along or walking or whatever.
Yeah, and it can be very costly for DUIs, insurance and attorneys and
your SR22 and your defense attorneys are all going to be thousands of dollars, I tell people. So
right. And when someone has been caught 2 or 3 times, now again, that's circumstances that's a little bit beyond just your first time out. You went out and had a drink or two. And does it go by the level which you breathe?
yeah, so you do have first offense, second offense, third offense, etc. And the sentence is different by what you breathe. So I'm not going to tell you all of them because it actually is different for first, second, third, and subsequent. So like a first offense is 10 and below, and then it's 10 to 15, and then it's 16 and above, and it's 0 to 30, 0 to 60, 0 to 90. Now most magistrates, statewide, not union, don't put people in jail for first offense where there's no true victim, because that's just not the way magistrate systems usually are set up. Is normally fines for first offenders across the board statewide, not 100%, but the vast majority.
Okay. Well, that's
And people like to ask me, I want to say something else, because we've done these for a lot in our career, but how much do you drink to see what you blow? I said, well, you can Google it and look at all the different little things that tell you how much you'll blow if you drink 2 or 3 or 4 by your body weight, but there is no science to that. Metabolism, your size, what you ate. I don't think anybody really knows what that level is when they're going to get to a certain level. So if you drink 2 and you weigh 140 pounds, you're safe. Nobody knows for sure.
right. And now, does it blow more? I was wondering if it blows more. Say, for instance, you just leave the bar, and you just got through drinking 2 beers, just drink them out then, and you get stopped within 100 feet away.
So theoretically, the policemen have to pull you. They have to go through the proper protocols of checking them. They usually give them sobriety test. So that takes a little bit of time. But then if they do charge them with driving under the influence, they'll carry them back to the jail. When you get to the data master room where the data master machine is, they start the process and they ask a bunch of questions. And one of them is, will you take the test or are you refusing? If they say they'll take the test, it requires them to wait at least 20 minutes to try to clear alcohol from the system that you're talking about that might be in the mouth. Now, where we came up with 20 minutes, I'm not sure if that's good, bad, not enough, but they can't just get you and give you a test in 3 minutes in South Carolina. You got to go and they got to watch you for 20 minutes on a tape, and that's supposed to try to get the alcohol out of your mouth area so you'll get a true reading.
Okay, well, I didn't know that. I thought they would have a little thing here on them, and they.
No, they don't do it on the side of the road in South Carolina.
Okay.
And again, we've done these, so there's a lot of technicalities and questions that come up. So nothing is a rubber stamp, and that's obviously why I tell people there's lawyers and there's juries. If everything just made you guilty by blowing a certain level, then you wouldn't need a lawyer. You wouldn't really need judges. You wouldn't really need jurors, because it would just be guilty and you just go to jail or pay a fine. But we do have a constitution set up with the right to a jury trial of your peers. So
Now, a lot of people are probably just about speeding and radars.
So in my career, I've done a lot of trials, both prosecuting DUIs and drugs and both defending them, but I've done very few speeding trials, and the reason being is because obviously once you have a $75 or $150 ticket, you really don't want to pay a lawyer that money, but you can challenge them. Most of the time, they're not as challenged through us because, again, we can't charge $50 or $100 to go to a trial with a jury, so we try to help people if they do, but police usually do a pretty good job of get you for a ticket. They'll sort of give you a break and then get people to go from a 4-point to a 2-point to do them a favor. And you can challenge radar. There is a whole book on challenging the radar, but again, I've done that so few times compared to other crimes just because of the nature of the money it would take.
Now, even me, I'm thinking this perception here. If you decide to go to, you say, for instance, you got caught for drugs, and you say, well, I want a jury trial. And some people tell them, oh, you don't want that, because if they find you guilty in a jury trial, you get more time.
That's not a rule, but it's very common. So what a lot of judges will say is you're rewarded for pleading guilty. So if you're looking at 5 years and you plead guilty, you might get probation. If you go to trial and lose, I tell my clients there's a good chance you'll get more than the probation or up to the 5 years, because so there's not punishing you for going for trial technically. It's rewarding you for pleading guilty. So that the person that pleads guilty should get a lighter sentence. Now, that's not to say some of the murders and things, because sometimes it's just you did something so horrendous, it's
Right.
life in prison. But a drug case, if you pled guilty, the judge is going to be more lenient than if you go to trial. And that's why some people get mad and say, well, the judge has let them out. Well, that's because you have someone who's charged with a drug, he pleads guilty, so the judge is lenient and gives him probation. Or if he went to trial, he gives him time. Well, if he starts giving them lots of time for the plea, now all the defendants that are pleading guilty will stop, because they wait a second. He's giving 5 years for everybody's pleading guilty, so they're all stopped. The system will bog down. So you need defendants to go in front of the judge, or you won't move hardly any cases.
Okay, that makes sense, because it takes a lot of time
I
getting a
would say the
jury.
average trial in big court, by the time you get the jury, there's 100-something jurors. By the time you pick them and you seat 12, most trials are probably a day. Some could be a half day. Probably most are a day, or a day 1 to 2. They usually start by Tuesday because you got to do the probation violations. So again, you wouldn't move it several cases a week, a month if you did that, and that's really slow.
That would bog it down real big time, wouldn't it?
They've got
Yeah.
thousands of cases everywhere.
Wow.
It's not going down.
Yeah. No, it's not, because I know they're building on to the jail,
Yes.
and it's not because it's not because the courts are slowing down. It's just more crime.
Well, in the jail, I mean, it's sad because people look at the amount of money we have to put into a jail, but we have to have the jail to accommodate inmates. And some of the problems with the jail system here, county jails are intended to have people for short 90 days or less, or waiting for their bond, or waiting for trial. But you're right. So they've had some that are there a year, 2 years, or multiple years waiting on trial, and that really bogs the system down, because I don't really know where else they're supposed to go, but the jail wasn't intended to hold people for years. The county jails, that's more for the prisons, but there are people there like that waiting for trial.
Right. And I know in our county jail, I know there's inmates in there that's been in there for years.
I don't have the list, but I know there's been one time, I think there was one that was there approximately 4 years plus. This was a county council meeting, I believe. And I believe there's been some there routinely that are 1-2 years. And really that they're supposed to be their short term and they get sent off, but the system can't get them all moved fast.
Now, do they still have what you call the Speedy Trial Act?
You do have it. So defense lawyers can make a speedy trial motion. Most don't, because I think you can. So there's strategies to it, but a lot of times I think defense lawyers don't, because I'm one of them, just because usually a case that gets older and older and older doesn't get hotter, it gets cooler.
Right.
And then you're more likely to get older, and it just might work out better in time. If you have somebody who's done something bad, like burglarize, and I've had him out, and the case is stalled for 3 years, well, I get to argue with the judge, it's been 3 years. He's been out, and he hasn't recommitted, so he's obviously showing he's readjusting and doing better. So sometimes people who do well, the delay helps show the judge that they're not really doing bad. So sometimes you get a speedy trial, it's been 30 days, the judge hadn't had time to see what he's going to do, and that helps judges too sometimes. They look at what you do when you're out.
So, actually, a lot of people think, when you go to jail or prison, that your life just ends, where actually you can really turn that around and make it positive and be a great citizen and become a good, outstanding.
There's a lot of people in town, and I won't use all their names, but that have been to prison and got out, and a lot have regular jobs, a lot have great jobs, a lot are helping and motivating other people that have the hard times. A lot of times someone who has a drug problem, who's been to prison, doesn't relate to me or you, but they'll relate to somebody who's been there,
Right.
or done that, or had a problem, because they talk with them and not to them.
Right. And they think, well, y'all never did have
Correct.
never been here or never done that. And I had a lady here that was, she's 7 years drug-free, and she owns her own insurance company now and doing great. And she came on and talked and talked about her experience with drugs and how that she was on them pretty bad, and but her life straightened out and much better. So it's hope for everyone, and that's what we got to look at.
We have, like I said, I commend law enforcement. I commend the courthouse, all the people that work at the courthouse, the solicitor's office, and we forget even the local churches, alcohol and drug abuse, C4 ministries.
Yes.
All those things help people that have either been arrested or had drug problems or personal problems or suicide problems. And everybody serves a good piece of the puzzle, even on different sides.
Yes. I commend Bill Randall. He's
Bill Randall,
another
Brad Goodall
fine
do really
example.
Both of them, Bill and Brad and their wife, do really good with C4. They've helped a lot of people. Some of my clients and people I've sent to them that weren't criminals, and they're not all people that are charged with some crime, the people that are criminals, but they've helped a lot of people.
Right. Well, Sammy, I really appreciate you coming on and explaining a lot of these things to us, because it cleared up a lot of stuff as we're right at the top of the hour now. And I really appreciate you coming and.
Thank you for having me. I do appreciate it. I will say I've spent my whole life talking or arguing, but it's way harder and more nervous to sit here with earphones and a mic than it is. So I commend you for being so smooth with it.
Well, it's really surprising that some people just get intimidated with these little cameras around, but
it's a little weird.
it is. All right. Well, Sammy, I really appreciate you coming in. And again, this is you was talking to Sammy Diamaduros, the Diamaduros Law Firm. Next week we've got another special guest, so watch on YouTube and Facebook, and you'll see who's coming next week, and we'll have them listed in. Well, I'm Jerry McKee, and thank you for watching Primetime with Jerry McKee, and you have a fantastic day.